T-minus 1 minute. T-minus 50 seconds. T-minus 40 seconds. T-minus 30 seconds. T-minus 20 seconds. Ten, 9, 8, 7, 6, 5, 4, 3, 2, 1, 0.
What is up, everybody? Welcome back to the Drunk Turkey Show. I'm Daniel. You're going to be riding solo, I think. Perhaps maybe Jaime will jump on a little bit later, or Blue. But for right now, it's just me. Today is going to be a day. Maybe we find out a little bit more information. We see, how things are going in trial. Some arguments are going to be made. Bryan Kohberger has a court scheduled for here in the next few minutes. I don't think that the trial is going to be broadcasted live, but I'll be searching the interwebs and stuff like that for Updates. Thank you, Glowbug, for becoming a YouTube member. We appreciate that. In fact, I think Sunday, I'll be doing a members only live, and we'll be raffling off one of these to a member. These are the wraparound koozies. So make sure you tune in for that, and you got to be present on that members only live. That'll be on Sunday. So Court TV has it. I'll see if we can go find it. I'll see if I can find it. So hope everybody's having a good Friday. We're gonna be doing another live tonight. We're gonna be covering this case, Bryan Kohberger, the Idaho 4. We're going to be talking about what we've learned today after a few hours of, thinking about it. And then we're also going to be covering the recent developments in the Rachel Maureen case. There's a video of a suspect walking out of another crime that he is alleged to have been, to have committed as well, out in Los Angeles. And sorry about that. And we're going to be going over that footage. We're going to be talking about those cases. So make sure you like and subscribe. Court TV has it. Yeah, I'm checking that. I'm not seeing anything yet from there. But I think it's supposed to be coming on immediately after it, after the hearing has concluded. Let me check a couple of my sources here on Twitter that I know are out there. So let's see. 11 minutes ago, waiting outside. So nothing there yet. Promoted post, eh? Let's try out this guy. He was out there an hour ago. Still nothing, no updates yet from the guys that are out there. I don't think that these guys have even been allowed inside yet. So we wait for updates. There's been some, I guess, some new documents that have been dropped. We can kind of go over and look into. I'm going to make sure I'm on. 71 pages. Huh. Now, is that interesting? No restreaming. Good to know. Good to know. Not seeing a link. If you can email it to me, I'd appreciate that. drunkturkeyshow@gmail.com. If you can email me the link there, that would be great. All right, so the state submits the objection to address the defendant's assertion that the standard of proof in the grand jury proceeding is beyond reasonable doubt. Far from the novel, the defendant's argument has made numerous appearances throughout the state in recent years. Even those punishing this jarring theory are forced to concede the whole of modern jurisprudence on the issue. It is against it. Mott at 6, and the state knowledge at every court. The state that has addressed this argument has solely rejected it. And so, from my understanding, what a lot of this is I guess other court instances where that are more recent than the 1887 trials and what was it, the Constitution of Idaho, that they had brought up as reason to have a higher standard for reasonable doubt, or for the grand jury, I'm sorry. And so here it was just, from what I understand, the state's argument against all of the arguments from the defense. And why this is so long is because they go into specifics of other court here, of other court proceedings. I don't know what you're doing. Let me put some music on, y'all. Let me know if it's not too loud, just to, while we're looking around and stuff, there's no dead air. So here's what we know about today's hearing. Let's talk about that. This is from Crime 2. This is Bryan Kohberger, the man charged in the homicide of 4 university students, is scheduled to be back on Sunday. Results of the motions hearing could decide if there will be a delay in the upcoming trial. There's been more than 7 months since the police arrested Kohberger. He's charged with taking the lives of Kaylee Goncalves, Xana Kernodle, Madison Mogen, and Ethan Chapin. The trial is currently scheduled to start on October 2nd. Now, to me, a lot of these things, and we spoke with with Zach, who's a attorney here in San Antonio. And when we were talking with him, I kind of asked him, a lot of these claims and stuff, it really does seem like mud being thrown up against the wall. And he kind of agreed with me on that. And he also said that, we came, in our discussion as to thinking that some of these motions and whatnot could be a reason to prolong the trial without having to forfeit his speedy trial rights, which I'm not sure what the benefit of that would be. I'm going to try to get Zach back on the channel. I'll be honest, I have no idea what would be the benefit of prolonging it. Does that mean that, if he asks for continuance or for it to be prolonged, would that essentially, what's the word I'm looking for? Would it then mean that the state could then take their time to start the process? I think maybe that's what they're trying to avoid. Let's see. All right, cool. We might got some news here real quick. So it says here from Chris Mitchell, seated in the courtroom for today's hearing on the state of Idaho versus Bryan Kohberger. On the docket for today is 1, motion to compel, 2, motion to stay proceedings. Should be getting on the record any minute now. That was 5 minutes ago by Chris Mitchell. Chris Mitchell on X. That sounds weird. It sounds like I'm saying he's on drugs. It's X, formerly known as Twitter. Oh, it's Chris Mitchell on X. Oh man, I'm not sure. Elon saw all the angles here. And so, let me go back to good old X. If you guys aren't following me, by the way, on X, at Drunk Turkey Show, and I'll get you there. All right, let's see. No, nothing there yet. Let me The trial is currently scheduled to start on October 2nd, 2023, with the state seeking the death penalty. Kohberger claims he was out driving alone at the time of the Moscow incident and could not have committed the crime of which he is accused. At Friday's hearing, a judge will consider 2 motions from the defense. One is the motion to stay at the trial based on concerns about grand jury selection process, including allegations of juror bias and statements made by the court, questionnaires that were missing clerical information, and alleged violations based on how jurors answered some questions. The state filed an objection claiming that the defense has not facultatively asserted a substantial failure to comply with the Uniform Jury Selection and Service Act. Prosecutors accused Kohberger, asking the court to grind the litigation in this matter to a halt. A second motion from the defense seeks more information about DNA evidence. Law enforcement collected trash from Kohberger's family home and used a DNA sample to link him to the knife sheath found at the murder scene. Investigators said that at least 99.9998% of the male population would be expected to be excluded from the possibility of being the suspect's biological father. The defense is asking for all access to profiles uploaded to a DNA database. This could include the names of other people who were potentially matched, as well as any unknown males. Other requests include a communications related to DNA testing and a history of unexpected results for the labs that did the testing. The judge could grant. Hold on 1 second. Oh no, that's not something different. The judge could grant, deny, or partially approve any parts of these motions depending on how the judge rules. There could be a delay in the trial. And so what's going on? Welcome everybody in to the DTS. It is just me and myself today, covering hopefully any updates that are possibly out there in the Kohberger case. Let's What is up, everybody? What is up? Thank you for being coming on in. So Alex Caparillo stated about 9 minutes ago that the court is about to convene in Moscow, Idaho, ahead of today's Bryan Kohberger hearing. I will be live tweeting using this thread below. Okay. So let's. All right, so okay, here we go. Bryan Kohberger and his defense team have entered the courtroom. Bryan Kohberger is wearing a gray suit with a blue and gold striped tie. He has entered the room calmly and did not appear to have much of an expression on his face. That's been kind of, it's the norm. That's what we've been hearing. That's what we've been seeing. He's not been his face has been very just straightforward, right? Not much expression, very little, but given the circumstances that he's in right now, it's kind of understandable in my opinion, but we've also seen him in other situations where, like, for instance, when he was, graduating, and getting his bachelor's degree, or master's degree, I'm sorry, in criminal justice at DeSales, there's a clip of him going up there and picking up his diploma, and same stone-faced look, right? And so the traffic stops that he's had that have been seen from before and after the incident, very, very similar, very much the same. Nothing changed too much. Let's see. So I'll continue. The judge is now taking his seat at the bench. And then 16 seconds ago, we are now on the record. Several motions are set for today. The state's motion protective order investigate genetic genealogy DNA issue, which is related to the defense motion to compel. Also, the motion to reconsider a speedy trial motion to stay proceedings alleging irregularities in the grand jury indictment, motion to compel defense of alibi, motion for scheduling order. All right. So things are coming on. Court TV. Let me see if they have a.
Here for a pivotal hearing. Hey everyone, Chanley here. I am taking over the Court TV Twitter page to bring you live updates from inside the Latah County Courthouse here for a pivotal hearing against the man accused of murdering 4 University of Idaho students last November. Stay tuned and follow this thread. Hey everyone, Chanley here. I am taking over the Court TV Twitter page.
All right, well, you heard her. Let's follow this thread. Let's see what she has to say first over here. Thank you, Jaime. I appreciate that. So I think I got the actual. I think they're going to strike me though if we play the court. Let me see. Now, what I might be able to do is when it starts, I'll unmute it because right now it appears they're like at a commercial break. I don't know. I don't know if this is right. There's just a bunch of ads. Yeah, that's what I'm going to do. If this ends up being, if I end up seeing, because right now there's a bunch of ads, I believe. If they end up going to the courtroom, I'll play the audio in the background. Let's see. Yeah, I'm seeing just nothing but ads on this thing. All right, let me see. I'm going back over here real quick. Yeah. Let's see what new update he has for us. All right, defense. All right, let's go through this real quick. The courtroom is not at capacity, but it is more filled than previous hearings. The Goncalves family is in attendance alongside his attorney, Steve Goncalves, told Banfield last night that he wants to monitor the hearing closely to make sure justice is served. Bryan Kohberger and his defense team have entered the courtroom. Bryan is wearing a gray suit, gold and blue striped tie. He entered the room calmly and did not appear to have much of an expression on his face. All right, so that's the part we were at last at. The defense will go first in discussing the motion to compel. There are witnesses expected to be called today, but first, some objections from the prosecution. State believe in calling attorneys to testify about legal conclusions and discovery dispute is not proper. She says that Ann Taylor is an attorney and should be able to make the case without calling on fellow attorneys to testify as witnesses. State is objecting to different defense witnesses, but says it never received a CV of witnesses, which means she cannot properly vetted by the prosecution. They say they feel ambushed. Whoa. Let me reread that again. All right. I just want to make sure I'm understanding this. Oh, you're right. That's true. That happens. Also, we'd appreciate it if you hit the subscribe button. It really does help out the channel, and it helps out our viewers and the algorithm and the whole 9 yards. We'd appreciate that. Thank you. All right. So, man, I thought I was sharing this whole time. It's really small. I don't know if y'all see it, but so it says here, I'm going to read it again. The defense will go first in discussing the motion to compel. There are witnesses expected to be called today. All right. But first, some objections from the prosecution. State believes calling attorneys to testify about legal conclusions and discovery dispute is not proper. So the defense is going to call up attorneys to testify about legal, like to testify about how. That's kind of weird. All right, she says that Ann Taylor is an attorney and should be able to make the case without calling on fellow attorneys to testify as witnesses. State is objecting to different defense witnesses, but says it never received a CV of witnesses, which means she cannot be properly vetted by prosecution. They feel ambushed. That's insane. The defense says its attorney witnesses are known to the state and have experience sharing with Idaho courts. Defense claims the prosecution knew that they were going to be called as witnesses for a long time and that they have traveled to Moscow today for the specific reason and should be allowed to testify. The defense says they are well versed in criminal defense and DNA genealogy. They will not be called as witnesses if this goes to trial, but are critical today when discussing the DNA evidence and why it should be allowed into discovery for the defense's preparation of the case. So they're trying to get the DNA thrown out, right? But I just don't understand the angle, right? Because the angle that they're going at it is that the genealogy could have been tampered, could have been, mishandled. The chain of evidence, like none of that. They have none of that, right? Because the FBI has basically destroyed it, right? Which I'll be honest with you, I don't like it either. In my opinion, they should hand it over. I just don't see where it's going to make a difference, right? So they created a profile or discovered DNA on the sheath and created a profile based on that discovery. Now, the after they had created that profile and put it into CODIS, and it came back with no hits, right? It came back no hits. That is when they said, "All right, we got to create a genetic tree to try to figure this out." And so they sent that DNA to a lab in Texas, right? Now, while they were doing all that, the FBI came in and said, "Hey, we'll probably do this a little bit better." So they took over that investigation, went and grabbed that profile. Now, this profile is separate from the DNA that was sent to CODIS to get tested to determine, if there was a match anywhere there. And so the FBI goes, picks up this DNA and this sample and runs their test, and they come back with a possible name of Bryan Kohberger. They inform law enforcement about it and, tell them, hey, basically, you might want to look at this guy. And, they had to create their case. Now, because the FBI did not directly take Bryan Kohberger's DNA and attempt to match it to the DNA that's on the sheath, it can't be used in court, right? Because it's speculatory still, right? The only thing that is concrete is his DNA, if it matches directly to the sheath, not his dad's, not the distant cousin, none of those things. It's his, right? So once law enforcement has Kohberger's name and they start doing this, their investigation, then after, getting his warrant for his phone pings, which I think the defense would have a much stronger argument for getting that thrown out, to be honest with you. But they got his phone pings, and those things let them know that he'd been in the area a few times, and that the night of the incident he turned his phone off and turned it on, and when he turned it off and where he was when it came back on. And so all those things are what led investigators to say, all right, let's get a warrant to test his cheek swab to the DNA that's on the sheath, and they became a match, and it was that octillion number or whatever it was. All right. So let's see. Mary State, are you seeing that, or is that something that you had read? Because that's what I read earlier. But if it's on now, I'd be interested in seeing where it's at. Let me see if it's on. I'm not seeing anything. Oh, nice. I mean, this isn't for the trial itself either. It's just to talk about the DNA today. So I wasn't surprised that wasn't going to be used. All right, let me go back over here real quick. Well, anyways, like I was mentioning or saying, so sorry, StreamYard it bugs out every now and then. All right, so to me, I just don't see how it makes sense, because the FBI isn't using that DNA against Kohberger, right? They're not using it against Kohberger. Oh, thank you for emailing me a link. I appreciate it. Okay. Yeah, this is just from Court TV's post. Okay, I thought it was actually the footage. All right. Well, thank you. I appreciate it. Though. All right. So, to me, I just don't see how it'll make a difference, because, the most they can do is get the genetic tree thrown out. And if they get the genetic tree thrown out, the prosecution's not using it. So they're back to square one. So I don't get it. But maybe perhaps they're hoping that whatever happened after the profile was created and checked with CODIS, I don't know how any of that stuff that happened after that can affect that sample. So I'm curious to find out what their defense is, or as to that. All right. Alex says, as for CV witnesses, defense says that the declaration has her background and training, which speaks to her credibility. Acknowledges that the declaration only came in yesterday, which is late, but said it was for undisclosed reasons beyond their control. I don't know. They're starting to already throw in some bamboozlement. Let's see. That sounds kind of crazy, to be honest with you. Like, this guy didn't know. I hadn't seen anything.
We're optimistic.
I feel for the families. From Court TV, it says the hearing is underway. Kohberger entered in a gray suit with a tie and gave a slight smile, well, less smile and more upturn of his lips awkwardly at the beginning of an awkward, brief smile. The family of Kaylee Goncalves is sitting in the gallery. Kaylee's mom looked at the person next to her and rolled her eyes at Kohberger's slight smile. See what any new. Yep. All right. Judge is concerned about opinions of the constitutional law and procedures of discovery. Judge says Ann Taylor is capable of making those cases, but says that their expertise on genetic genealogy has merit. Says it would be wise for him to allow it on the record. Judge says he doesn't want to get into arguments about law, but wants to be able to hear from both sides. Judge denies the objection of prosecution and will allow witness testimony. That is a win for the defense. Clarification on the defense motion to compel. Defense does not have the lab results of the other 3 unidentified male DNA samples, 2 from within the house and 1 from outside of the house. That is what they want. Prosecution says they have provided everything they have. That is. So the prosecution does not deny that those results exist. They just say they don't have them, or that they gave them to the defense and the defense hasn't found them. I just don't understand why the prosecution wouldn't say that they've provided, that information to them. They say they've provided everything they have. Maybe that's just a coverall. Like, we're not in court. Maybe perhaps they just, for every question that comes up about motion to compel, is the answer going to be, we provided everything we have. All right. So that's a possibility. I would have liked to have seen something like, we've provided those lab results in the Exhibit A. If that was said or put in there, that would lead me to believe that the defense just hasn't found it. I mean, there's 51 terabytes of information in there. So let's continue. The judge says there has to be some level of trust and discovery. Y'all are sworn attorneys. Mr. Thompson is saying there's one more lab report coming your way. Judge asked prosecution to reach back out to the lab and make sure there are no other existing documents and results that the defense does not have. Defense is adamant that the prosecution has given everything they have and calls the pleas for more information speculation. WFLA. All right, let me see. That's not now. I mean, they're talking, but that's not. Whoa, everything just kind of turned black on my end. Let me know if you guys can hear me in the live chat. The defense calls first witness, Stephen Mercer. Brief pause in proceedings to excuse the other witnesses that will be testifying today. Mercer is from Maryland and is a licensed attorney in D.C. in the field criminal defense with specialization in DNA. Thank you, Maggie. Thank you for letting me know. No other updates yet, y'all. Sorry for my being quiet there. Apologize. So, no updates yet, but they're really going to be attacking this DNA. And I mean, at the end of the day, that is what really pins Kohberger to the inside of that house, right? The vehicle is in the area, but from our understanding, there's no footage of Kohberger going into. There's no footage of Kohberger going into the house, right? And so there's nothing there putting him there. There's no DNA outside of what's on that sheath, which is supposedly, allegedly been carrying the murder weapon, right? Well, that is from outside of the house. Somebody brought that inside the house. There isn't anything that states that that Kohberger actually grabbed that or held that. There's been many cases with DNA and transfer DNA, and this is probably what they're going to be talking about and why they're probably bringing up another attorneys is in their experience in other cases, how was DNA used. I think there's one that's been going around where a guy's DNA was under the fingernails of a victim who ended up being that it had to do with something about grabbing the same door handle, right? And he was arrested and charged for taking that person's life, and Come to find out, he didn't do it. And so, in this case, I think there's a lot more that point into Kohberger's direction. Like, for instance, you have the, his phone activity that night. I find it super suspicious. Super suspicious. Thank you, Mikey, for your $2 super chat. John Madden, a true crime play-by-play. Smash that like button. Thank you. I appreciate that. I also do actual football play-by-play on State of the Steelers. I'll be doing that tomorrow night at the Steelers versus Buffalo Bills exhibition preseason game. All right, doesn't seem like there's any new updates through right here. Proof theory, he wouldn't be in jail is facts, though. Like, yeah, I agree. I mean, there's a lot there, in my opinion. It's circumstantial because you don't have like a camera showing him going in. You don't have, a clear picture of his license plate. Now, maybe perhaps there's something else about his car that identifies that car as Kohberger's car, like, a sticker or a, something that makes it unique, right? Not just the front license plate, but something that you can combine with the front license plate and say, hey, it's his car. Because, like, for instance, if he had a sticker, somewhere on his vehicle and or a dent or a scratch that's noticeable, or you can see it on camera, in the same location, a lot of vehicles can get dents, scratches, or stickers. But to also have that plus the front license plate missing, it makes that evidence stronger, in my opinion. Yeah, witnesses are being called. I agree with you, Donald. I'm strongly suspect that it was him. With what is out there right now, the evidence that's out there, I don't know if he's going to be convicted. I couldn't say he'd be convicted. My biggest question, and we had a lawyer on here, was, getting, the first thing that law enforcement did after they got his name from the FBI was pull his historical phone data on the 23rd, right? That's what the search warrants indicate. Now, we assume that they got the name, on the 19th, based on the New York Times article. And so, I would assume that the first thing that they probably did was to try to go find him. I realized he wasn't at his residence, hadn't been there for a couple of days. They may have even gone to his work and just kind of asked around. You know what I mean? But I think the first thing that they tried to attempt to do was probably that search warrant that came out on the 23rd of December. And that was for his historical locations from his using his cell phone data. And, based on the affidavit as to the information that was used to acquire that warrant, I'm a little bit concerned. They're basically saying, because he had specialized training that would have taught him how to elude law enforcement, because they would have taught him how, investigative techniques and law enforcement tactics as far as how to investigate crimes and through technological forensic means. And that because he was aware of those things, that he would not that's enough for a warrant. I don't think it is. I think they also point to the Reddit post that he had, and what they're saying is that he was inquiring about committing a crime from violent offenders and all these things, right? And I get it. If he wasn't writing a thesis and his major and minor not be criminal justice and psychology, I'd find that suspicious as hell too. But the fact is, he was a criminology student, a master's student who had already graduated, with a bachelor's in psychology. I don't find the line of questioning that he had to be suspicious. And so because of those things, I just don't think that that's enough to get that warrant. And that's going to cause some problems, because I think that was like the first thing that the defense, the prosecutor or law enforcement did when they found out who he was. All right, we got some more updates. Mercer says he's not here to discuss Idaho's discovery rules or offer legal opinions, but rather focus on his expertise in forensic DNA interpretation, who must comply with their duty to investigate. Mercer says forensic evidence is often central to a case. Mercer says it is essential for the attorneys to know about the details of testing and investigating of DNA evidence. There are pre-trial concerns involving suppression and Fourth Amendment issues. There has to be a factual investigation of conduct law enforcement took during forensic analysis. Was it fast and loose? Sorry, I got a child's mind sometimes. Was there searching of databanks that violate the terms and conditions of the databanks? Attorneys must know these things ahead of trial. Now, I get it. I agree that attorneys, and the person who's being accused of a violent crime should know these things. But, I had over one of my friends not too long ago. He's actually going to be coming out on the podcast sometime in the near future. He's a current police officer. I don't remember the county that he's a police officer in, but he's also the lead singer to a band called Kohler Lane. And he was over at my house. His wife and my wife are good friends for the longest time. And I was talking to him, about this situation. And, we came up with a scenario. And the scenario is one that I've talked about somewhat with the guys. And that is if like, for instance, let's just say Big Blue is an officer and Jaime is a seller of narcotics, and I'm a purchaser of those narcotics. And one day he shortchanges me or something, and I get pissed off, and I end up going out and telling Big Blue, like, hey, now I'm not going to show him the narcotics or anything, because then I'd go to jail, right? Probably wait until after those narcotics have been consumed, and then I'd go up to Big Blue once the effects of those narcotics have worn off, and said, hey, you need to keep your eye on Jaime. Heard he's selling dope or whatever the case may be, right? And the officer's like, well, let me take a statement from you and this, that, and the third, and I'm like, no, I don't want to do that. I don't want, it's your job to be the cop. You go figure it out yourself. I'm just telling you, keep your eye on him. So that alone wouldn't be enough for me to go, or for Blue to go out and get a warrant, right? That's not enough. He'd have to build a case. And what he'd do is stalk the house, park out there, see if anybody's driving around all hours of the night. And hold on, we got another update. DNA profiles contain a vast amount of information that is often private, and attorneys need to be able to access and evaluate that information without violating privacy rights during trial. So basically what they're saying is that they're arguing that it wasn't basically fair that they found Kohberger through a means in which they did not have access to use, such as the genetic tree, right? The thing I don't like about that, for a person who's trying to, say he's going to exonerate himself and stuff. I mean, I get it. You're going to try every avenue to get the case thrown out and stuff. But this is like, they're putting a lot of eggs in this basket. It's like, There's nothing out there that points to anything of innocence whatsoever. They don't have any witnesses. They're going to try to get some during trial, right, for his whereabouts or whatever. They're hoping that one of the state's witness will say something that will prove it was not Kohberger that was at that house. But they don't know which witness, apparently, because they would have signed him up as a witness on their own behalf. And it's only through cross-examination, which, there's a possibility that if the state doesn't want to call this person that the defense thinks has some evidence that could exonerate Kohberger, then they don't. And then the defense wouldn't be able to call that person up because they're not on their witness list. They're only on the witness list of the prosecution. And so it just doesn't make sense to me. What's up, George? How's it going, my man? Let's do it. Let's see. None there yet. Still same. But yeah, back to what I was saying. So if Jaime then, or Big Blue then goes and starts to watch Jaime, right? And Mercer says it's nearly impossible for the defense to know what type of witness to call on their client's behalf for trial if they don't obtain all the discovery for scientific testing of the DNA evidence samples. This is absolutely crucial to get that discovery. Now, is this referencing the 3 unknown males' DNA? If it is, I 100% agree. And if it's still unknown, that's huge, right? Because even though Bryan Kohberger is not, DNA is on the sheath, were the other guys investigated as hard? As far as the DP case going after it right now, I think when cases and charges and things are brought up initially, the heaviest and the most, the bigger ones are going to come out. Now, typically, by the time you get to the trial aspect, like to come trial, those things can change, right? Like, and typically they do, like depending on the strength of the case. And so by the prosecution asking for or going for the DP right away doesn't necessarily mean that they have the strong evidence against him. I honestly think that the evidence they have against him is circumstantial, and it's going to come up. It's going to be up to the prosecution at this point. There's a lot we don't know about, right? Like, the probable cause affidavit is, going to give us about 90% of the evidence that they had at the time of his arrest. There was a lot of stuff that happened after his arrest, right? His searches, what if there's no searches of the victims, but at 10 o'clock or 9 o'clock while he's or 8 o'clock in the morning before he takes off to go back out there and check the area, what if he Google searched something like stabbing in Moscow, Idaho, right? That would be pretty damning in my opinion. Or it may not be related to the victims per se, but if he's researching or Googling things like that, I think that would be huge. And that's something we wouldn't know right now, right? We also don't know how close Kohberger was those 12 occasions. Now, I believe that the cast is pretty accurate. It'll give an area of about a few feet. I wonder if any of those 12 occasions that he was there, if he ever actually made entry into the house. Those are things we don't know and that we'll find out in court. But what we do know is that his phone was off during the commission of the crime. He was out driving around, per his own words, and that his DNA was found on the sheath inside of this house. And he's driven quite a weird ways. All right, let's see if there's anything else. All right. Where's that other stuff that he was saying? All right. Deborah says they don't have to follow up on every dead end in order to have a case against someone who fits more than one piece of the puzzle. I agree, but when you have DNA in the vicinity of where the bodies were also, there then begs the question, is it possible that somebody else was involved? You don't have any cooperation from Bryan Kohberger at this point, right? He hasn't even stated that he has done it, much less that he knows that there were multiple people that could have done it. And, if there's multiple DNA in that house, and there's an unknown DNA, I guess the defense can argue that, well, they didn't even look at that other DNA. There's no other DNA of Bryan Kohberger in the house outside of the sheath. There's, I'm assuming there's none underneath the fingernails of the victims whose lives were taken in a horrific manner that was in close contact. A knife is very close. It's not like a handgun where you can be a few feet back or further. And so you would expect there to be some sort of DNA there. There's been a lot of rumors that have gone out, but some pretty close to the situation, some from family members of the deceased, saying that there was a large fight or fought like hell, things like that. Well, if those things were accurate, you would expect there to be some sort of hair, sweat, saliva, skin transfer, something in the house. And if the only DNA that's there is Kohberger's that is on the sheath, and it doesn't really align with that narrative. Now, if we come to find out that, 3 of the 4 of these individuals were asleep at the time, and only one person was, really awake and able to defend herself, then, that makes more sense, right? We don't know those things, though. We don't. But I do think that it is important, especially if there's only DNA that's found on the sheath, that officers would have investigated that unknown DNA to exclude them, to rule them out, make sure that they aren't involved in the case, make sure they have an alibi that isn't just driving around, right? Like he says, as far as Bryan being fairly expressionless, a couple of times he's tried to smile, he's called awkward. If he doesn't smile, he's maligned for that. Damned if he do, damned if he doesn't, right? Well, I don't expect him to smile, especially during this. I don't expect him to have happy emotions throughout court. His life is on the line here too, right? And so, but what I'm referencing to is even when he picked up his diploma, or and you would assume with having accomplished such a great feat, you would get more than just a smile as well. But that doesn't mean he hurt anybody either. There's very few pictures that you'll see of me smiling. A lot of videos you will. I like to laugh, but pictures, yeah, I don't smile myself either. So. Do we know where the other DNA was found? According to the documents, it's just stated that the DNA was basically just found in the vicinity or in the area where two of the bodies were. So we don't even know if it was where Maddie and Kaylee's bodies were found or Ethan and Xana's bodies were found. I don't know. The judge does not want to risk an appeal and a do-over. Also, it is clear the prosecution is hiding something. Maybe. BF stated she saw a naked man running away. Exculpatory evidence. I don't think so. I don't see how that's excluding him from the case. I mean, even if she did see somebody naked running away, could that not have been Bryan Kohberger? You know what I mean? So it's not necessarily exculpatory. It's just something that is different than what Dylan stated. Now, Dylan's testimony of what she saw that night isn't going to hold a lot of weight, in my opinion. Right? So even if she's completely wrong or was, hallucinating or whatever the case may have been, it doesn't change the fact that, there's a white vehicle that's driven around in the area, regardless of who's driving, right? I think it's Bryan Kohberger, but it could be somebody else. At this point, he's still innocent until proven guilty. But there's a white car driven around, and the moment that it stops being seen in the area, some weird stuff starts being heard, right? You hear whimpering voices, a thud, dogs barking. We know the crime is being committed, and this is at the time where those weird noises are being heard. And then you have, after those noises, you finally see the white car taking off, and it is, seen leaving at a high rate of speed. Right. So Dylan's testimony only really says that Bryan Kohberger could fit the description of the person. She doesn't exclude Kohberger. Like, for instance, if she had said that the subject was of Hispanic or African American descent, well, then that would exclude Kohberger. She said, I saw somebody who was 5'4". That would exclude Kohberger. And so her testimony about what she saw doesn't necessarily say that it is Kohberger, but it is saying that it is that it could be Kohberger. And that on its own isn't enough for his arrest or any of those things. But the sheath, his vehicle not having a front license plate, his phone activity attached to it, all those things combined with also the person that Dylan saw not excluding Kohberger, builds a heavier, solid circumstantial case, in my opinion. And that's true. When did BF say that? I don't know if she said that or not. I don't think she did. Here's the thing about it. I wouldn't be surprised if it was true. And here's why. Because in Vera says 12, have you seen legit sources for that information? I can't find one. Personally, I think the person who committed this crime was wearing a PPV suit. I mean, that's what I would do. Yeah, but here's the thing. He'd have to get in his car, right? You don't want to leave DNA evidence in your car. So I can see there being clothes put outside in preparation of coming out of this crime scene, knowing that you're going to use a knife and knowing that you'd be covered and having the ability to change out of clothes very quickly and jump into something very fast and get out of there. So, like, for instance, let's just say he did have coveralls and maybe some thermals underneath, right? And it's cold, and he goes in there with thermals, coveralls, and some Vans shoes, the ones that you can slide your feet in and out. They're pretty common with college students, right? And you use those because you know that there's a lot of people that go to this house, and there's going to be thousands of footprints all over that place, especially if he was aware of the party that was there and in the area the night before, right? The night of the 11th going into the 12th, there was huge parties out there. And so I wouldn't be surprised if he runs out, takes off his clothes, and then changes into something else to get in his car. That way he wouldn't transfer a ton of evidence, place his clothes that he was wearing covered in DNA in a plastic bag before taking off. So, and I wouldn't be surprised if it's true to a certain extent, but we all know that there's, when it comes to rumors, sometimes there's a small amount of truth to, what's being spewed out there. So maybe she did see something, or someone did see somebody outside without, your clothes on or something like that. And it changed into like a big old story about somebody running out there without clothes. Let's see if there's anything else new coming up. Oh no. So Alex stepped out of the courtroom briefly for a live shot. Will return live tweeting in about 15 minutes, as long as the bailiff allows him back in. All right, so now we got to find a new while he's doing that. Is this guy live tweeting? He was there earlier. Yeah, he is. All right, there was no questions from the prosecution, and Mercer was dismissed. Attorney for Stephen Mercer, Maryland, he had a 30-minute testimony. And it was just basically, I'll read the tweet. It says, Attorney Stephen Mercer of Maryland, and now 30 minutes into his witness testimony from Bryan Kohberger defense about his DNA genetic genealogy expertise, explaining why discovery of such material is critical to testing legitimacy of results from family tree profile development. No questions from the prosecution, and Mercer is dismissed. Judge calls a 10-minute break in the Bryan Kohberger case, dismisses at 11:32 a.m. Second witness is up next in the Idaho hearing. So witness will come back. They are dismissed briefly for 10 minutes. That happened about 4 minutes ago or so. So we got 6 minutes until we get to the other side. Right. And Dylan and the other roommate were in paralyzing shock for 8 hours. Now, in that audio that's next door, there's whimpering, there's a dog barking, there's voices. Well, there's no screaming. There's a thud, but there's not kicking or sounds of pounding. Is it possible that they weren't really sure about what happened in that house that night? Is it possible that, they thought, well, one, Dylan says she thought Kaylee was playing with the dog. The dog barking for... I mean, we weren't there. You would assume that dog's bark would be a lot different than when Kaylee would be playing with the dog, right? I would assume it'd be different. But to give them the benefit of the doubt, how long did Dylan know the dog? How long or how often was the dog there? I think there was Ian Harsh said that he didn't even know they had a dog. There's been some, witnesses that say that they've seen the dog more often at Jack DeCore's house than at her house. Right. So maybe she wasn't that accustomed to the dog as we assume. This was a house that had a lot of turnover, a lot of people in and out. So let's see. Oh, thank you, 12. No, the dog swapped. I would assume they did something with the dog. Like they found some hairs at Bryan Kohberger's apartment, one that they thought could have been a dog's hair. And so, with that being said, I think they would have thought that they would have checked Murphy and gotten his, DNA. I think they would have swabbed him as well, just in case, like, for instance, something comes back as dog slobber in Bryan Kohberger's vehicle. Or let's just say the dog, had slobbered on that bed at one point, right? Or earlier that day. And during the scuffle, it got on his arm or something, and then it transferred over to the door panel, right, while he's driving. Yeah, I think they probably would have. Thank you, Cammy. I appreciate this. Thank you. Yeah, our email is drunkturkeyshow@gmail.com. If you guys are interested in these koozies, we're selling them for $12 a pop. With shipping, it comes out to, I think it's like $15. It's a little bit more than that, but we cover the rest. I'll show you guys. So here's one, and it'll end up doing that. This is the light colored one, the new logo. Then we have a dark colored one. So if you guys are interested in that, you can order them on Cash App, basically by sending us through, it's $, Drunk Turkey Show, $15, and put in the description which one you want. The light one, the dark one, how many you want, if you want multiples, and put your shipping address, and then we'll have them out to you. We've had a few people already purchase them. We have our first shipment going out yesterday, so those should be at those houses and not too long. Now, if you want to inquire about certain things or other merch or stuff that we have, please hit us up in there at our email. If you end up sending us a Cash App, I know that's happened a couple of times, and forgot to put which one of the koozies you want, just let us know who you are in an email and which one you want, and as long as we haven't shipped one out for you, we'll get it swapped out. So let us know. So, and I think that this is why, I think this is what the argument is. So Dove Magic says, fact is, we don't know everything in the search warrants has produced yet. They are still sending things to the defense as it progresses. They're still investigating him. They're still searching him. They're still doing all those things. And here's the thing. I think that if it is in the, when you have a lot of evidence like this that you got to go through, it is kind of in the interest of the defense to have that speedy trial, because with so much information and so much stuff, you know, you would have the defense would be at an advantage because of the likelihood of building a case against somebody in a short period of time, right? Especially with so much evidence to go through and things like that. If, you know, the downside though is if the defense goes back and says like, hey, you know, the downside first and foremost is the fact that, well, the defense also allows themselves a shorter period of time to create a defense for their client. You know, they don't know all the evidence right then and there. They haven't had as much time to go through the evidence as prosecution and law enforcement has, right? Because, you know, prosecution and law enforcement basically had a 7-month head start, or 7-week head start. I'm sorry. How long that they had all the evidence that they were examining and going through to build the case. The prosecution has to, or the defense has to get all that evidence, go through it, figure out how the prosecution plans to try their client and how they're going to attack their client. And in my opinion, hold on, let me see. So they're going to try to, you know, attack that aspect. I forgot where I lost where I was at. I apologize. I know where I'm at. I know what I want to talk about, but I forgot where I was going with it. Well, anyways, so if the defense goes in and says, hey, we want to have an extension, right? We're not quite ready yet. Well, then that will basically wipe away that speedy trial, right? And I think that would give the prosecution time to build an even stronger case. And I think at that point, that'll give them the opportunity to extend things out as well. And this could end up turning into a several year type thing, or at least 1 year type thing, where before it actually goes to trial. And so, according to the prosecution, they say that they're fighting for the October date. We'll see if that's true. We'll see if that's true. I've seen what? There's absolutely no excuse for people to be defaming. Double jeopardy rule does make the speedy trial beneficial for defense. That's true. Somebody's psychic. He would have to be a ninja to take out 4 people in that amount of time and get away without leaving DNA. I mean, it depends. If 4 people were wide awake and, you know, active, I would agree to that. But you had 2 of the victims that were in bed. You had they were highly intoxicated and most likely very much asleep during the attack. At least one of them was. I don't know, you know, how much of a fight the other would have had, you know, depending on, you know, how soon they would have waken up. I mean, if certain areas of the body are attacked, like the neck or lungs, it made it get difficult for a person to scream or do much. And so I think that It's very much possible in that aspect. And then we've also seen pictures of the mattress. And the mattress picture that we saw, it appeared that there was only one body on the mattress because there were some stains there. And it did look like the neck and chest area was attacked there based on the stains of the mattress that we were able to see. And if that was just one body, then that was probably Xana and Ethan's bedroom or bed. And if there's only one body in that bed, that means that one person was laying down when attacked or fell down on the bed when attacked. And, the coroner did say that they were most likely asleep during the attack. If somebody's asleep while they're getting attacked, there's no screams. We don't hear that from the audio. The dog doesn't start barking until 4:17. I think it's quite possible. 10 minutes or, even 9 minutes. That's a long period of time. And we'll start the clock now. And, you guys tell me if you think that was long enough. All right, let's see if Alex is back and if court has started. Nothing there yet. Oh, the defense is going to call 4 witnesses, and we've only heard of one. It could be a lengthy trial, y'all, or a lengthy hearing today. We're just like at about 1 minute and 12 seconds in that countdown. That was a long ass minute and 12 seconds. All right, and we're back here at 11:48 p.m. as the judge returns Bryan Kohberger hearing. Attorney/doctor Leah Larkin is up next for the defense witness testimony. Now, I saw the information, the court documents that was supplied by the defense for like Leah Larkin and some of their other genetic witnesses that they plan on bringing up, I guess. I'm wondering, where they were going to use that. And I guess this is the where that's going to be at this trial. And in that documents, there were certain things that were said, like, I've seen mishandling. I've seen where, officers or lab technicians had, contaminated evidence based on this or that, and law enforcement did this. And I get it, but how does that affect the Idaho lab, the lab in Texas, and the FBI? Unless those labs that they're referring to, that they have seen, all of this mishandling, they've seen all this, contamination by law enforcement and first responders, and those testing those DNA samples. Unless all that came from, the Idaho labs or the FBI or Hawthorne, I think that's what it's called, or Hawthorne, the lab out there in Houston or near Houston. Unless those things happen there, I don't see how those things can affect each other. That's like saying, something that CNN said you're going to go take out on Fox News or vice versa. They're just because they're news stations and televise on certain things. Doesn't make any sense to me. Oh, I got 4 minutes. So it's been 4 minutes. Kevin corrects himself. It's a genetic genealogy expert, PhD, not an attorney, that is taking the stand. Let's see if Alex is back in as well. No. I just wish they would freaking televise this thing live. Like, what difference does it make whether it's live or, immediately after the hearing? I don't get it. I just don't get it. I'm gonna check Court TV, see if that's true.
Opinions about sort of constitutional law or
It is on.
procedures of discovery. I think that's fully capable for all of the counsel here and for me. Those are going to be my decisions. However, in reading through, and I have read through all of the declarations, pointing on specifically genetic genealogy and their experience with that within the law, I think does have some relevance, potentially. And I think that it would go to the weight of the consideration. The other thing that I am concerned about is this is a death penalty case. And if I deny particular presentations that one or the other side believe have.
We've hit the top of the hour, so we do have to squeeze in a break, but you won't miss a moment of the Kohberger.
All right, they're going to a break. Can y'all hear it? Let me know. I paused it down. But when it comes back from commercial break, I just want to make sure everybody can hear it. It's low. Yeah, it is low. Well, I don't have it all the way up. All right, now I've turned it all the way up. When it comes back on, I'll check the volume. But it's going to be behind. That's going to be referencing everything from earlier, right? That had happened. They're going to be about, I think, 90 minutes or an hour behind. We've been doing this for an hour and a half. So that's from the beginning part of the trial. So we'll still be looking, especially throughout the breaks here. We'll be looking for updates that are up to the second. And this is from Kevin Fixler at KFixler on Twitter. or X, formerly known as Twitter. Yeah, the last thing he said was just they still had a break here on Court TV. And we're at 9 minutes and 25 seconds on our, well, a little bit more than that. We're actually approaching 10 minutes on our clock. So if Kohberger was in there 9 to 10 minutes, right now it is at exactly 10 minutes since we started our clock. That's a long time. That's a very long time, in my opinion. Especially if the goal was to get in and out, and as soon as he heard somebody or was aware that somebody had noticed him, he was gone. We have a bit of a video that's going to be coming out that gives our theory on the entire case and situation. The who, what, when, where, and whys. All right. Another 10-minute break called by judge after the state objects to PowerPoint presentation of genetic witness, which prosecution has yet to review. They're doing that now following 2 objections. Bryan Kohberger again leaves room at direction of bailiff. Come back at 12:10. So in another 10 minutes. Man, Tommy Chong, you need to hit me up for some ad revenue, man. I've been showing your ad all day. That's quite possible. I'm not saying that there isn't. I just think that there is the possibility that it could be done by one person. I don't know that it was done by one person. And, I would assume, what is the likelihood, that one person goes and commits a quadruple homicide and not get their DNA anywhere outside of the knife sheath? All right. So nothing in the house on the victims, nowhere. And then we multiply that by 2 by adding another suspect in that house. That person did even a better job than Kohberger, unless they're one of the 2 or 3 males that had their DNA unidentified that prosecution has yet to hand over to the defense. But if that isn't them, then what are the chances that there's two guys that are that good? I don't know. This is true. Xana was awake on TikTok and just ordered DoorDash. Now, we know that the sliding glass door was left open when police had arrived. From my conversations with people close to the case, it is believed that sliding glass door was left open the entire time, from the time that the person that committed the crime entered and then left. Is it possible that while Bryan Kohberger was upstairs, after leaving the back door open, that Xana felt a draft or maybe even heard some noise herself, got up, went to go see, saw the back sliding glass door open, said, I think someone's here out loud, to herself, turns around to walk back towards her bedroom where her boyfriend is asleep. And as she's walking in, unfortunately, allegedly Kohberger's come down the stairs, walked up behind her and attacked her from behind. Now, seeing that there's somebody a male, large, probably is starting to wake up from hearing this. He probably is going to immediately turn his attention to him. All right. Now, the initial attack probably just, stopped or knocked out, incapacitated. Xana may not have, I don't know. I don't even want to go that far into it. And then, focus in on Ethan as he's getting out of bed, or maybe perhaps he's still in bed. So I think that there's a world or there's a possibility there where that's very likely, probably could be what happened. And that's what I think at the end of it, we'll find out what happened is probably what happened. Number of minutes to take 4 people. It was, he's seen leaving on Wilentz Drive at 4:20. At 4:07, he's coming back around and going to go park. So I'm assuming that, him getting out of his car and walking about 40 steps probably take 30 seconds or so, maybe less than that. And, get in the house. He's probably there by 4:09 and out of there by 4:19. So about 10 minutes. And, as we indicated, 10 minutes can be a long time. I mean, that's longer than 3 rounds in boxing. And if 2 or 3 of the victims were, asleep or intoxicated or combination of the both, it's not that unlogical to think. Yeah, I agree with you, Rich, buddy. It would take about 15 seconds. Very easily. I think we sometimes we get confused with what we see like in the movies. All right, it's back.
Have to do with the other DNA that the state doesn't have complete discoveries to us that are included in that third motion that you call it up for today. But they focus has been the genetic genealogy piece, but I wanted to make sure that was still in the scope.
Well, my understanding was that the state did provide all the information about the laboratory, we'll say the laboratory DNA that was, that analysis was not related to the genealogy DNA. Am I mistaken about that? What are you saying that it didn't provide something?
Your Honor, in our third motion to compel, we had a section called standard lab discovery, and that has to do with other DNA profiles found at the scene. They have provided full discovery for the sheep, the DNA found on the night sheep, but not the other 3 unidentified male DNA samples, 2 from within the house, 1 from outside the house.
All right. So if I'm understanding your question there, or your assertion that we're talking about 3 potential analysis of DNA that was not provided to you, but that has no connection to Mr. Kohberger.
Correct.
Any response?
Your Honor, we didn't realize this was going to be an issue today. We had given everything that we received from the lab. They'd asked for DNA workups on other people. To the extent that they don't have them, they weren't done. We can't produce something that doesn't exist. We provided everything. There's one outstanding lab report that relates to the forensic examination by the lab personnel of the crime scene itself. We'll be receiving today. That's the only outstanding lab report. Everything else, along with all the notes, is what there is, and it's been provided to the defense. They're hoping that there's something else there. It's not there.
Taylor?
Well, Your Honor, it's part of our third motion to compel. It's still something that we don't have. We also don't have the unexpected corrective actions, unexpected results from the Idaho State Police Forensics Lab for the 6 months before and the 6 months after November 13th, 2022. We did get some, but it's a narrow scope, and we asked for the full year, 6 months before and 6 months after. That's also in our motion.
I understand your responsibility is to turn over every rock, but you can't get things that don't exist as well. So, I mean, there has to be some level of trust in discovery. You're all sworn attorneys. And so Mr. Thompson is saying that there's one more lab report that is coming your way today, I heard you say.
Maybe not today. We are waiting to receive it so that we can process it for discovery. It's supposed to be in any time.
Okay, I misunderstood that. So it's coming soon. It has to come soon because we're 6 weeks away from a trial. So we're going to be very rushed about a lot of things, but I'm going to talk about that a little more later too. So what about the other claim, Mr. Thompson? Do you want to address that? The other mistakes?
Corrective action log, unexpected result log. We have that in part, but not the whole thing.
I don't know what exists that we haven't received. We provided all the requests to the lab, and they've assured us that they have provided us with everything they have within the scope of those requests. I'm not sure what else to say. I mean, we can make a supplemental inquiry to clarify that after we finish in court today. But I'm kind of sitting here saying, Judge was giving me everything we know to exist.
Well, that would be wise to check on that.
We will.
Because we don't want this to come back on the eve of trial.
Yes, sir.
Or, 4 years from now at an appeal.
Yes, sir.
So we want to make sure that we have combed through all the information that has any bearing or argument of bearing on this case.
Ms. Jennings is making a note right now. We'll send the inquiry out later today.
Okay.
Thanks, sir.
Your Honor, just for some clarification, we also ask for all emails, text messages, along with electronic messages or other messages. Some have been provided, but we don't have assurance that that's all. And so for the same reason, we want to make sure that we have the complete file.
You see that?
Mr. Thompson.
We had told them.
Let's bring.
I'm gonna take the chance and just play it. They're taking a break again. But it says here, followed all 3 victims on Instagram. Y'all see that? Now, I'm going to show this. I'm going to try to show this. I need you guys to hit that like button, share it, tell everybody we're going to be watching it here, because there's a good chance that it's probably going to get flagged for me showing it. So at least do me a favor, hit that like button. But followed all 3 female victims on Instagram.
Proving what you're trying to prove beyond a reasonable doubt. I think that the DA...
They're just talking, conversating about. All right, while they're doing that, let's come back here, see if there's anything new, because that video is kind of old from before. No, I know. I have one on there. I have to pause it every now and then and stuff, but I've done that before and it's still not make a difference, to be honest with you. All right, we got some stuff here. All right, so next witness for the defense is Leah Larkin. She is from California and is a professional genetic genealogist. She admits she is nervous today. Larkin has begun by researching genetic genealogy back in 2014. Her biology background helped her pick it up quickly. She is self-taught, but now teaches courses at Salt Lake Institute of Genealogy. Larkin says that she was approached by the defense. Her role is to educate on how genetic genealogy works. Sorry for stepping out again for another live shot. Court has recessed for 10 minutes to allow both sides to review PowerPoint presentation that Larkin brought today. Court is back in session. I'm back in the courtroom. The PowerPoint presentation will be shown, and the prosecution will be allowed to cross-examine the witness at a later date once they more thoroughly review with the presentation on their own time. So we're definitely not going to get a resolution on this aspect today, because they're going to have to come back with it after the fact. All right. No, the word redacted was just near where they started to talk about him, but I guess there was some information that wasn't redacted, that was redacted, and that was where his body was located in the room. That wasn't in there. Just that it was in Xana's room, or that he was in Xana's room. They didn't talk about, I think there was one aspect where it was an autopsy that was done like over a month later to determine, his cause or the manner and, how he passed, being from a sharp edge knife. So those are the two things that didn't come out. But I speculate, and this is my speculation, that the reason why his body isn't described in the probable cause affidavit is because I think they had to move him. Kaylee Goncalves told me that she spoke to, or that the family had spoken to Ethan's best friend and confirmed that what News Nation had stated, which was that he had discovered the bodies and was one of the persons that called 911, and also confirmed to me that he was called over and that he attempted to check in on the room, but the door was blocked and couldn't get through by supposedly a person on the ground behind it, that he had to push through the door, and he enough just to look in and saw what he saw and called 911. And so I think because they had to, PCA says that the door, as the officer's approaching the bedroom, that he can see Xana on the floor in the bedroom through the doorway. So that door had to have been open, which means that his body, or Ethan's body, would have had to have been moved. And maybe perhaps that's why it's the only one that's not listed, because it wasn't in the position that it was left by the person that committed the crime. I've heard that, but I haven't seen where that's true. I think a lot of people are saying that it's true because I think at one point the law enforcement had said that autopsies had been done that day, and then that was before what is indicated in the probable cause affidavit. But I don't know if it's been confirmed true. When we spoke with our forensic medical legal forensic death investigator, and we asked her about that date, and she had mentioned that given the size of Moscow and their department and stuff, that autopsies probably weren't conducted there. they had to go somewhere else, and sometimes those things can take be a little bit lengthy when it comes to the timing aspect, even in a high profile case. So I don't know. And if he did have two, I'm not that's crazy. I don't know. I would assume one would have had to have been at the order of the family, of his family. See anything new here? Let's check Kevin real quick. Judge overruled the state's objection on the foundation of Larkin's expertise. We're all caught up. All right. So we got a couple more things. The presentation shows how genetic genealogy works. Larkin explains that there are 3 different types of DNA. And now explaining how DNA sampling works, she explaining that the process of genetic DNA testing, companies who take the DNA and tell you your ethnic and genetic background. He then goes on to tweet, Think, Ancestry, and 23andMe. They have separate databases which do not share their results with one another. Genetic genealogists like Larkin have access to the results if they are invited. Interesting. No, there's still a way. You're on the court hearing. I mean, BK is so innocent it isn't funny. It isn't really a fact, is it now? Like, he hasn't even told anyone where he's been at. And, you know, for me, I think that's because if he were to tell them, yeah, I was driving around and, you know, the direction I went was north towards, you know, Coeur d'Alene or south towards Johnson, Idaho or wherever, I'm sure there would be cameras that would have caught his driving in and or out of certain areas that he would have been caught on, that would have corroborated his statement. But the fact that he doesn't want to give that up at this point and wants to wait until court to discuss his alibis, because once, you know, trial comes, it's not like the prosecution is going to have the opportunity to go review those those surveillance tapes and things like that to determine whether or not Kohberger was there or not. And or also he's probably stalling on time to give it because he's hoping that, you know, if he were to say that he was in this area or that area, that those cameras would roll over. But if the law enforcement is smart, they probably got cameras going in and out of several cities in the area and don't see Kohberger going in or out of any of them. Because then if they did and they didn't turn it over, well, that would be the Giglio evidence. But, and also, or Brady, I'm not Giglio, Brady evidence that he's not doing something right. But also, the fact is, you know, if he was in fact innocent and was driving around and not in the area, why wouldn't he say that? So that way his prosecution, you know, I mean, his defense team can go get that evidence and submit it into court so that they can file for a motion of, you know, to dismiss the charges. And then Kohberger can go and get a lawyer for a civil suit against the city of Moscow and the FBI and ISP and everybody else and sue the living crap out of everybody. All right? But he's not doing that. That tells me he's so guilty, it's not even funny. But, you know, everybody has an opinion. I just, you know, thought it was weird that you're saying that it was facts. Let's see.
Media intensive environment, and I don't want them to be bothered by the media locally.
The law library.
May I escort them there?
Sure. Thank you. Sorry, Mr. Mercer.
Hey, so here's the thing, though. He did. He had his phone with him that night and showed that he didn't. And he turned it off in and around the time of the murders. Somebody left a knife sheath. Somebody did drive a white Elantra. I mean, maybe he drove his own car because he didn't have the finances to buy another one just for this crime. Now, for me, I think you're absolutely right. And my thing is, why would you question, or if somebody made so many dumb mistakes, like drive their own car, take their phone, and leave the knife sheath with DNA, and you think that those are very easy, dumb mistakes that we get somebody caught, why are we surprised that somebody's caught? I don't get it. I don't get it.
What do you do for work?
I am a licensed attorney in Maryland in the District of Columbia in the field of criminal defense with areas of specialization in DNA and forensic litigation.
How long have you been an attorney?
I was licensed in the state of Maryland in 1995 and in the District of Columbia in 1997. I'm also a member of several federal bars, including the Supreme Court, where I appeared as co-counsel on Maryland v. King, a DNA database case from 2013, as well as the Fourth Circuit, the DC Circuit, and a number of federal district courts.
I want to back up a little bit and have you tell me about your educational background.
So I have an undergraduate degree, bachelor's degree in English from Syracuse University, 1984. Juris Doctor JD from the District of Columbia School of Law from 1994.
And you mentioned you have a specialty in DNA. Where does that come from?
So my experience with DNA began with the first constitutional challenge to Maryland's DNA database statute, and that started in 2002 in the case of State v. Raines, where it raised a Fourth Amendment challenge to the compelled collection of DNA from convicted offenders. Prevailed on that case in the trial court. It was appealed to the Court of Appeals, which is now called the Maryland Supreme Court. The Maryland Supreme Court, in a sharply divided 4-3 decision, reversed, sent it back for trial, tried the case, and that was really the beginning of my experience with forensic DNA litigation.
All right, so that stuff that we've talked about, they're quite a bit behind. But I do want to bring up to attention real quick. Alex Caparillo says that Larkin, and this is who's on the stand right now, says that she has experience as an unknown person to a positive match using DNA evidence. A list is provided pending on a database that is providing that is providing. Family trees can be linked to a database if that is the tester's choice. She says it's time consuming. Larkin says matches that a genetic genealogy can provide can only be considered approximate, never definite. This is why you never hear it's 100% match. Now, I don't think this really helps the defense, because that is what the prosecution has been saying. They've been saying that the FBI did not, who are the ones that created this genetic tree, did not, connect Kohberger to the case, right? They never tested Kohberger's DNA to the DNA on the sheath. which is why prosecution isn't using it. And so I don't, this horse and pony show, to say that, oh, the genetic tree, blah, blah, blah. There's so many things that could have happened wrong. I get it. Throw it out. Don't use it. And it's effectively not. You're back at square one. In my opinion, it's just to try to throw in some reasonable doubt. Like, for instance, they're going to say, oh, there's the possibility that this genetic tree was contaminated or something to that nature, right? And yet that has nothing to do with Kohberger's cheek swab DNA that matched to the STR profile created by the Idaho State Lab that was submitted to CODIS before any genetic tree was ever created. So I think it's a horse and pony show, to be honest. So I don't look like nothing new on Kevin Fixler yet.
And then I'm also a member of the National Criminal Defense Attorneys Association and a number of local bar associations in Maryland, as well as the State Bar Association.
You mentioned forensic genetic genealogy personnel. Can you tell me your background related to that?
So following really the advent of forensic genealogy in 2018, that is when I had the opportunity to litigate cases, criminal cases involving that technique, the testing and the investigation related to the testing, and to receive discovery of the testing, and the interpretation of the test results that were obtained through searching of genetic data banks.
You are here on Bryan Kohberger. How did you become involved in this?
Yeah, so the question was, what would a reasonable defense attorney do when confronted with DNA evidence that needs to be litigated? What are the minimum practice standards? So I'm not here to...
All right, this is all about DNA evidence.
All right, so 12 Gauge Phillips says, I don't know how factual it is, but WSU Momkin mentioned parallel crimes, 2 different crimes happening at the same time. Could this be possible? I mean, it could be. I mean, if you go look at the, for instance, the Delphi case, right? Yeah, Ron Logan, who was a prime suspect in that case, right? And one of the reasons was because he created an alibi before the bodies were discovered on his property, right? And so investigators believe that if he was creating an alibi before the bodies were discovered, before the knowledge that a crime was committed, then that shows evidence of having knowledge beforehand of that crime. And that's what they used to get the warrant to go search his house, the whole 9 yards, right? But the reason why Ronald Logan created that fake alibi and stuff wasn't because he was responsible for the passing of, Libby German and Abby Williams, but it was because he was out violating his probation. See, he had a record for drinking. I think it was drinking while driving, or DWI, driving while intoxicated, and was on parole or probation, and was not allowed or was not supposed to be drinking or operating a vehicle. And this is my understanding that if he had, that would be a violation of his parole / probation. I'm not sure which one he was on, and that he would end up going to jail, which ended up being what happened. Right? He ended up going to jail for like 18 months or something like that. Now, his crime is parallel to the crime that was happening with, against Libby German and Abby Williams, right? They don't intersect. They don't cross. They're not tied together, but they run parallel and close enough where you can almost connect a dot there. And I think maybe perhaps if somebody says that there's a parallel, crime going on or investigation, then that means that, something else may have happened or been happening and it have nothing to do with the case. So if there was, like, for instance, a parallel crime being committed, like the use of recreational drugs, right? That's a crime that's occurring there, but it has nothing to do with what happened. So it would be parallel, I guess. So I don't think it means anything, to be honest with you. But I don't know. I don't know the full context of Kim's conversation with whoever told her that there was a parallel investigation going on. So, that is important to know when trying to determine the value or the importance of the information. Is, what context, what was said before, what was said after, to get a true understanding of what was meant or said. But when somebody says something is parallel, that means that they don't cross, they don't intersect. It's happening at the same time, but not necessarily connected. Hope that makes sense. The popcorn. Humans make mistakes, but DNA doesn't lie. That's true. It is not live in the courtroom. It's probably about an hour ago or so. That's why I go back to this. I'll check on it. See, right now they'll be right back. They're not doing anything. But it's about an hour behind. What I have going on the screen on X, not the drugs, the formerly known as Twitter, is the most up-to-date information. Let's see. Thank you so much, Miller Aaron. We appreciate that. $25 super chat. Thanks for covering Daniel. If he is innocent, I wonder why he never went to the cops and said, hey, I was in the area and I drive a white Elantra. This is what I saw, didn't see, etc. He had nothing to hide. 100%. Especially if you factor in the fact that, his studies in criminology and criminal justice and, psychology and everything else that he studied into. He was attempting to be an intern at the Pullman Police Department. Going and reporting something, especially, if you were out driving around that night in a vehicle that is similar to the vehicle that they're looking for, 100%, I would definitely believe that, a person with that beforehand knowledge or expertise would definitely go in there and try to say, hey, I was driving around, I wasn't in the area. But, according to my theory, which will come out a little bit later, if the goal and the object was to elude officers and investigation, going in and talking to law enforcement is sometimes one of the big red flags. Richard Allen did that. He went to say he was on the trail, the whole 9 yards. And, people investigate or insert themselves in the case. So he may, in my opinion, purposefully not gone forward because, well, one, he did it, and two, had he gone forward to say that he was driving his car in the area in an attempt to make him look innocent, I think that would have brought attention to him. And I think he would have known that. And that's why I don't think he's like Papa Rogers or inside looking or outside looking. I don't think he's any of those people, just because of the fact that he would have known that that's one way to investigate him. But, Court TV said just a second ago, or put up there on the screen, that Bryan Kohberger was following 3 of the victims on Instagram. I'm curious to know where they got that information. They seem to be back.
Well, there are a number of reasons why it's crucial for the attorney to investigate any testing of evidence that is central to a case. And again, here it's an environmental sample of trace DNA that is being tested. And so it's essential for the attorney to know, for a number of reasons, about the details of the testing and the investigation when we're talking specifically about forensic genealogy. Number one is there's pretrial concerns. And those pretrial concerns that can be raised would involve suppression issues and potentially Fourth Amendment issues. These are questions that are very much evolving in the state of our litigation. But to understand the viability of a Fourth Amendment challenge, there has to be a factual investigation. There has to be a determination of the conduct that law enforcement undertook during the.
So I'm going to answer this. If he was following them on Instagram, why would AT and court docs say that there was no connection to the victims? And well, that was from the defense. We have to keep that in mind, that was the defense saying that there was no connection to the victims, right? And that would allude us to believe that that would indicate an online presence, right? But does the defense consider somebody following, a certain person a connection if that other person isn't following them back, right? So if it was a one-sided follow, is that a connection? I don't know. Maybe not. And that might be why they're indicating that. I will say this. In my interview with Kaylee Goncalves, Kaylee's mom, she had indicated to me that they were notified a couple of hours ahead of Kohberger's arrest of the upcoming arrest of Bryan Kohberger. And at that time, they searched his social media accounts and discovered that there was a couple of accounts that were linked to him at that time. And when they looked at them, I think there was 3 accounts. All 3 were following Maddie. I think 2 of them were following Kaylee, and only one of them was following Xana. And so, how accurate those things are or how true those are, who knows? And I think it's more important when he started to follow them than anything else, because if he followed them after their passing, I mean, a lot of people followed them after their passing. So I don't think that'd be strong enough evidence if it was after the passing. Now, if it was before, I think that would be very strong evidence. So we'll see. I wanted to bring that up.
Concerns about reliability. And by reliability, I'm not talking necessarily about the forensic genomic profile, but I'm talking about the STR profile. And again, because as I understand it from the pleadings, there were multiple tests on the same evidence, environmental sample trace DNA. One produced a STR profile that I understand from the pleadings is represented as being a single source male profile. The reliability of that needs to be investigated, and certainly through one aspect of that is investigating the laboratory documentation that is provided for the STR testing. But we also have to appreciate, and again, I'm not a DNA scientist or a biologist, but I'm an attorney that works with experts, and I need to know what type of expert to hire. And one thing that I do realize in looking at this is when there's multiple tests of the same piece of evidence, and you have a genomic profile, in other words, potentially the entire human genome that is typed from this environmental sample trace DNA, or at least an SNP profile, which is somewhere in the neighborhood of 700,000 locations of data. What does that tell us about the STR profile markers? So, for example, the STR profile markers, which are typed, are 20 out of 30,000 STR markers overall.
So Josh says there are interviews with Steve and Kaylee's sister saying they didn't know BK's name the night before. They weren't allowed to know. They were just told an arrest was being made. Didn't even tell them the state. I don't know. Christy told me directly that they were aware and that they have screenshots of Kohberger following the victims. And so I don't know. There were certain things that, especially like when it came to some of the stuff that they may have known, or how they felt that they wanted to remain quiet about at the time. I know there was a pretty strict gag order going on at the time. And one of the things was, like, for instance, how they felt about Kohberger's innocence or guilt. And, and I can probably talk about it now because they've been open about it since. But at the time, they said, she told me, she's like, we don't want to taint the jury pool or anything by saying anything, that we think this guy did it 100%. But they felt very confident, like pretty close to 100%, that this guy was the guy, and had some pretty choice words about it. And so, understandable, their daughter was, their daughter's life was taken away. And, I would be upset and have very similar choice words to say as well. But, there was something that they wanted out there, that they're confident. That was a statement they wanted out there at the time. They're confident about it. And they're going to wait to see until trial. But, since then, they've come out and said that they think that Kohberger's the guy. And so, and they've had some, other type of choice words about how they felt about the situation. And so I'm not going to get into what words were said to me, but, you can probably guess. I mean, if you had a child taken away from you in this horrific manner, how would you feel? Right? So what I understand from this here, this trial, though, going back to this hearing and what the defense is asking for and why they're bringing up attorneys, is to show that, this is why they need this information from an attorney's aspect, or from an attorney's standpoint, to properly defend their client. Right. And it's nothing against, the validity or the accuracy or any of those things. Right. It's just solely for that purpose. It's that, hey, they need to know this information. This information needs to go to them because of this. All right, let's see. We had a couple of new things that had came up. I saw. Give me a second. All right, so the crime scenes and genetic genealogy DNA should not be considered the same. You spit in a tube for 23andMe, you may only have traces of touch DNA on a knife sheath at a crime scene, for example. All right, and the point is that the more DNA that is available, the more you can scan it for matches, and the more likely you can find a highly accurate candidate profile. So it sounds like at this point, with the witness that they have currently, not the witness that's on, that was on here earlier, that guy, that was like an hour ago. We spoke about that already. They're attacking the fact that you can get a more accurate profile by having more DNA than just what is on the sheath, which I agree. So they're saying that the amount of DNA that is out there on the sheath isn't enough to develop an accurate profile. We'll see. I mean, according to, and that's for the genetic stuff. I'm sure they're going to try to put that onto the DNA that was directly attached to Bryan Kohberger, through that buccal swab on his cheek. They're going to try to say that, well, you're still testing it against the same amount of DNA that was collected for that STR profile, and that it's a small amount. And so that's the angle of attack here. They want on record, in my opinion, that there's a possibility of mishandling or contamination of DNA, even though that DNA isn't being used against Kohberger, right? They want that in court, that there's that possibility, because they can say that, they can bring that up, that there's a possibility that the handling, of the genetic tree, blah, 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 blah. Now, it's going to be up to the prosecution to explain that, even if that were the case, it doesn't change the fact that his DNA matched to the sheath, right? Now, the defense is probably going to come back and talk about the amount of DNA that there is and attack the fact that there wasn't enough to create an accurate profile to test against, the population. We already know that the prosecution has stated it's like octillion times, or, the population or whatever, octillion, 1 in octillion. There's only like 4 billion people here. So there's, you'd have to go to people on other planets to find a possible match, right? And so it's going to be interesting. Like I said, there's a lot of hurdles in this case. I've always thought that, law enforcement got it right. That his phone activity the night of the incident, plus the fact that he didn't have, the license plate, the car, the DNA on the sheet, it all points to him. But that's not without saying that there aren't hurdles. There definitely are. So it says here, now talking about forensic genetic genealogy, it deals with criminal court cases. It is work that is done for law enforcement. Clients are also medical examiners when dealing with unknown human remains. Larkin doesn't do this work, but knows about it. Okay. I don't see there's anything new. Nothing there. Kenneth Fixler is an investigative reporter for the Idaho Statesman. He's one of the guys that I'm also looking into. Kevin says, take this for whatever it's worth. Bryan Kohberger appears to be relaxed at the hearing. His eyes up, focused on witness testimony, and occasionally Ann Taylor as she asked questions. The prosecutor when they object. He briefly smirked as witness joked about spelling specific terms. Mike comes in with a $5 super chat. Thank you so much, my man. The prosecutor stated they reserve the right to use the sheet DNA at a later time, so it's a problem. But I feel that they're going to use the DNA on the sheath. What they're not going to use is the genetic tree that was created from the DNA on the sheath to point at Kohberger. What they're going to use is Kohberger's DNA from his cheek that they swabbed after his arrest to confirm that it was Kohberger on that sheath. So I do think that they are going to use it. The prosecutor reserving the right to use the sheath at a later time. Like if it was the genetic tree aspect to use it at a later time, I don't think so, because the genetic tree and the FBI didn't test Bryan Kohberger's DNA to the sheath. They only tested, that DNA and then created a genetic tree. So they didn't confirm that it's true, right? And they destroyed their work prior to, like, it doesn't exist anymore, according to court documents in the prosecution. So I don't think they're going to use that aspect, but they are definitely going to use the DNA in this case as far as, tying Kohberger's actual DNA to it. I think it did say that, though. My work's going off there. It's all good, my man. It's all good. I'm looking at this guy playing. I go off memory all the time, too. All right, let's see. Any new tweets? None yet.
As well as the family tree build-out, the attorney can't investigate that. And in that situation, by not investigating it, is not complying with their duty to investigate that is required, especially in the capital case.
I've heard you say that when you have a sample, in this case, a DNA sample from a knife, that is STR testing done, and then when you go, when you have genetic genealogy testing, you end up with whole genome testing or an SNP profile. Did I understand that?
Yes, and it's unclear to me at this point what type of genomic profile was developed, whether it was a whole genome sequence or whether it was an SNP profile, which contains about 700,000 locations of very personal, private information.
I think I heard you say that no matter which one of those were done for genetic genealogy, that you need to look at those to test the reliability of the STR profile. Did I hear that right?
Yes, so this is, as an attorney, and not a scientist, but as an attorney who has a duty to investigate, this now is an area where the attorney will look to retain a qualified expert who can evaluate and assess the linkages between the SNP profile or whole genomic profile and then STR profile. To be sure, an SNP profile or forensic genomic profile can't be searched and coded. It's not that type of situation. They can't be directly compared. But there are techniques that can evaluate if it is a whole genomic profile, you would look to a scientist who then would be targeting the areas of the whole genomic profile that comprise the STR profile to then evaluate the reliability of the STR profile, the potential for any mixture, the potential for any artifacts in the STR profile. Or if it's an SNP profile which doesn't have the STR locations in it, then you would look for an expert who understands that the neighboring regions around where the STR markers can be evaluated and assessed to provide information about what the STR markers would be.
Can I clarify something? Sure. So what you're saying is that you need to look at the advertisement, the qualified.
All right, here's what I think the point of this is. The genealogy was used.
All right. So, question: did they create the IgG tree? Would they still have granted the arrest warrant? 100%, because they didn't use the IgG to get the arrest warrant. The IgG profile wasn't used at all for the arrest warrant. What was used in the arrest warrant was the match of the father's DNA from the trash disposal, from the trash pickup on December 27th. That is what was used. And that is also 100% separate from the IgG tree. So, yeah, 100%. They were granted the arrest warrant without it. If they had it, if they had to use the IgG to get the arrest warrant, then one, that would be in the case, and that would be given to prosecute or given to the defense, and that would have to be used at trial. Like, there's no ands, ifs, or buts about it. But yeah, no, they didn't use it for the arrest warrant. So in essence, if they didn't create it, would they have been able to get the warrant? Yeah. Now, would they have been able to find him is a question. Probably not. Probably not. I don't think they would have found Kohberger without the IgG. You know, Kohberger would have had to have committed another crime, or maybe even if he would have gotten a job at the police department somewhere. You know, you go do your background check at that time. They do fingerprints, they do take DNA, they put you in the system, not just because they want to make sure you haven't committed a crime yourself, but also for future crimes, like if you're at a scene or whatnot, and in your DNA it contaminates that scene in some form or fashion, and your DNA is picked up, it doesn't come out as a unidentified profile, and start stirring up like theories and rumors like what's going on now with unidentified profiles. And so because of that, officers would have to give their DNA. And so at that point, Kohberger would have been caught because, his DNA would have gone into the system and would have matched to the DNA on the sheath. And that's when he would have been arrested. Right. To his knowledge, because to anyone's knowledge, we didn't know that DNA was left on that sheath. There's a good possibility he thought, I left it behind, but I cleaned it well. There shouldn't be any DNA on there. Right. But nobody's perfect. People make mistakes. And so, he would have been busted at that point regardless. So for me, it's not about the IgG. That's just what pointed in his direction and got the ball rolling in that direction faster. Once they had his name, they still needed to build a case without using that information. And that's when they go into the phone pings and they go into all those other aspects. And then eventually, arrest him after compiling their own evidence against him. But great question. That really was. Let's see. Well, 100%. All opinions are welcome. I prefer to be around, like individuals when I'm discussing something. Like when I have guests, majority of them have been, when we're talking Kohberger, have been guys or gals that thought he was innocent or going to be acquitted or whatnot, because I like the difference of opinion. You have to have a yin to a yang. That's how you end up progressing. You can't be one-sided in everything. You can't have too much of one side. That's when things get bad. You can't be, too much power to one area too. That's bad. You have to be, it's got to be balanced, right? And so long as people are respectful and have a different opinion, I respect it and I'll go with it. And I'll talk about it. Now, if it makes sense to me and it's an opinion that possibly change my mind, then, we'll see what happens. But, I get along with everybody. My own wife thinks that Kohberger is maybe not so much innocent, but that there's enough evidence to believe that he didn't commit this crime. And we get along. She thinks he didn't do it. Well, she was stronger earlier. Let's see. What did they use to get the phone ping? They used a warrant, a search warrant. Now that warrant is one that I question the strength of. I've questioned the phone ping warrant because it was only based off of his schooling and his knowledge of potentially being able to elude law enforcement because of his specialized training. I don't think that's enough. And nothing new yet here. All right. Larkin wraps up testimony at 12:59 p.m. Judge calls her testimony very educational. He plans to take a lunch break for 1 hour. The Bryan Kohberger hearing will reconvene at 2 p.m. That is going to be, exactly 1 hour, including with 2 more DNA-related witnesses. So that's going to be it for court for now. Again, this is from earlier.
Line is Jaywalk Kim, who published in the journal Cell about how an SMP profile can be linked to an STR profile. And that's by zeroing in on sort of the neighboring regions and examining those. So again, I'm not a biologist or a scientist, but I'm an attorney, who has a duty to investigate. And to investigate requires hiring experts to examine this data, this discovery that hasn't been produced yet. And so that's why the minimum practice standard is to get that discovery so that the attorney can then assess that discovery and then retain a qualified scientist to help understand the extent to which the SMP testing will shed light.
100% Art Nixie. The phone ping warrant was absolutely because they had his name from the IGG. I 100% agree with that. But they could not say that on the warrant. You're absolutely right. So that's why it's dodgy. I agree 100%. But the thing is, they used it. And they did it. They used his background as a possibility or a reasoning for the warrant. Now, that background, that phone ping warrant was the first thing that they did to him. So if I was his defense team, I would attack that. And if you get that thing thrown out, there's a possibility you can get a lot of it thrown out, because that was like the first step. Fruit of the poisonous tree. Now you can articulate, that like for instance the father's DNA pickup, that wasn't a part of the branch of the phone ping warrant, right? Because once something is fruit of the poisonous tree, you can't use it anymore, right? And so could that be that could be very crazy, that could be very hurtful for the prosecution. But we haven't seen the defense challenge that yet. They're challenging the DNA. Maybe it's to come. But that makes me believe that if you guys are setting reservations in October for this case, I don't know if you might want to put some warranty on that, because I don't think it's happening. Let's continue to listen.
And family trees constructed.
That was going to be my next question. I heard you say that we can't look at this whole genome sequencing or the...
They had Bryan Kohberger's name from the IGG December 19th. The phone ping warrant was December 23rd and was granted December 23rd and received the data on December 23rd per the probable cause affidavit. They had his name before. What they had prior to his arrest was a warrant for the cell tower nearest towards the victim's residence. And so what they did was they checked the cell tower and checked for phones that connected to that cell tower, and Kohberger's phone wasn't one of them that connected there. But that was early on. They looked at that. They looked at the fact that he didn't have a 2011 and 13 Hyundai Elantra, and I think they moved away from him. And it wasn't until they got that IGG report on December 19th is when you start seeing a move on Kohberger. And even in the state's own words, they state that the IGG can only be used as a last resort when there is no lead at all, and all law enforcement, conventional law enforcement techniques have been exhausted. And there still is no lead. So that leads you to believe that at the point or at the time of when the IGG was used by the FBI per their standard operations and procedures, their SOPs, indicates and tells me that Kohberger's name was not on the radar until after they did that. And according to the probable cause affidavit, it isn't until after December 19th when, and all these docs, show me a document before December 19th that indicates or shows anything about Bryan Kohberger. All of them are after December 19th. Every single one of them. And so the pings was not before they had the DNA.
For example, who the population of related people are, because often from my work on the forensic genealogy, what I've seen is that when a match is found, when the STR match is found, then all building out, all further testing stops on the forensic genealogy side. And so it's important to know who hasn't been tested on the related person side in terms of developing cross-examination about the limitations of the statistical tool that the state uses in its case to demonstrate the rarity of the match that they're presenting.
Have you received genetic genealogy materials in your piece of data when you say that?
Yes, so which wasn't surprising to me, because even though typically the government doesn't seek to introduce the forensic genealogy, in its case, it nevertheless is evidence that is a scientific test of material in the case. And so the discovery rules typically call, for example, in Maryland and the District of Columbia, call for discovery of scientific testing of evidence in a case, and that's regardless of whether the government is going to introduce it or not. DC is a little different, where it requires either materiality showing or that the item is introduced into evidence. And so even if there's a limitation on the item being introduced into evidence, that really goes to the item tested, which here is the environmental sample of trace DNA. And of course, the government has twice tested it. And so for the attorney to be able to fulfill their duty to investigate and satisfy the minimum practice standards, they should have access to the scientific testing of that item of evidence, which is central to the case.
Just 1 minute. Mr. Mercer, I don't have any other questions. I'm going to be hanging on just a minute. Trust me.
Thank you. Thank you.
Your Honor, I have no questions for this witness, and I will be making our arguments.
Okay, thank you. Okay, may this witness be excused?
And so they're going for a break. It appears that they're going to be gone for the next hour or so. We're going to take off as well. I want to thank everybody that tuned in, asked questions. We're going to be going live again tonight at 7:35. We're going to cover everything in whole. We're going to talk about this hearing. We're also going to look into Rachel Morin's case. We're going to look into the video and the footage of the possible suspect that has been released. You don't want to miss it. It's happening tonight at 7:35 p.m. Central Time, 8:35 p.m. Eastern. On the West Coast, I believe that's 5:35. Make sure you like, make sure you subscribe, and hit that notification button. That way you're notified of tonight's live. I'm doing a twofer, and then on Sunday I got a members only live where we're going to be giving away to a lucky member one of these koozies. Don't want to miss it. Don't want to miss it. Hit that like, hit that subscribe button. See you tonight, y'all. Peace. Wait, hold on. I have not heard anything yet, but she has been reached out to. All right. Peace out, y'all.